I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into compilation 109, and today we're going to be doing something new, and that is we're going to be focusing solely on one sovereign citizen. And that sovereign citizen today is a man by the name of Cardell McCreary out of the state of Michigan. If you have never seen an appearance of Mr. McCreary, then you absolutely are in the right place. Now, let me, guys, give you a heads up. Mr. McCreary, most of his appearances were very long appearances. So what I am going to do is I am going to put the links down in the description to the full proceedings to some of these appearances that you are going to see. You already know there will be no commentary added to this compilation, and there will be chapters added for your convenience. Listen, Mr. McCreary definitely is a handful. A lot of these proceedings have some very serious charges, so I encourage you to watch this compilation, but also go and take your time going through his proceedings. I think we did about 4 videos on him, and it contained, I believe, 1, 2, 3, 4 appearances, but the last appearance, it took 2 videos, but very serious charges. Definitely had his sovereign citizen head on. I mean, he went super hard on it. So that's all I'm gonna say, but you'll see in this compilation. But I encourage you to go later on and check out those full proceedings. Now, guys, it is about that time. Let's go ahead and jump into 109.
Which legally denotes a corporation.
Thank you, sir. I'm not the typist around here, sir, so we're going to go with it the way it's spelled.
May I please address the court, sir?
Sir, I'm sure your counsel would suggest that you not do that, but you have a right to do that if you want to over your counsel's very solid legal advice.
Judge, if I may briefly, Mr. McCreary did not want us to represent him. We tried to represent him. We would like to help him and represent him.
I'd like to represent myself, sir. Under Michigan Constitution 63 Article 13, represent myself, Judge.
All right, sir. It appears that you have a desire to represent yourself. Let me just ask you a few questions. You're aware that either right now or at any point while this case is pending, you can have the assistance of counsel should you so desire. Are you aware of that?
I am aware, sir.
All right, and it's your decision at this time to proceed without counsel, is that correct?
That's correct, sir. Appropriate persona under Michigan Constitution 1963 Article 13, sir.
All right.
I am very well versed in law.
Hold on, sir. Hold on. While you do have a right to represent yourself, you do not have the right to talk over me, sir. So let me say a few more things. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, which we've just discussed. And if you cannot afford an attorney, the court will provide one for you. In fact, we have several attorneys here today who are very capable. Of course, you can turn down that constitutional right, and it appears that that's what you're doing. Let's see, you're charged here with 1 count of misdemeanor assault or assault and battery. Maximum penalty is 90 days and or $500. And court's going to enter a not guilty plea on your behalf, sir. We're going to hear a few words from the prosecutor, and then it'll be your opportunity to speak if you so desire. Mr. Prosecutor.
Thanks, Your Honor. Again, Steve Vincent on behalf of the people. The complaining witness, Your Honor, in this case is a police officer. Apparently, during prisoner transport, the defendant walked past the police officer who was in and around the area while the defendant was being escorted to the holding cell, and defendant took it upon himself to lean towards the police officer and spit on him. As a result of the defendant's actions, the people will be asking for $1,000 cash bond.
Mr. McCreary, anything you want to say as to bond, sir? I do caution you not to discuss the alleged facts of the case, but it's up to you.
Well, I first would like to challenge personal jurisdiction, subject matter jurisdiction, territorial jurisdiction. This is a structural error, Your Honor. Under MCL 767.24, Judge, this statute of limitations has told this is a structural error. This is prosecutorial misconduct under Michigan Michigan Rules of Professional Conduct 3.8, sir. I was in the Department of Corrections from, I believe it was I know it was 2002. I was released in August of 16. Paperwork, everything. I've been filing complaints against the prosecutor's office. Kim Worthy, where a judge heard it on appeal, Kirsten Frank Kelly. It's been crimes against me by the prosecutor's office. And I would like to move for a change of venue where it's clearly documented, Your Honor. And the statute of limitations has told, I don't know nothing about this case. Why wasn't I processed or liens checked before I was released from prison? I've been home 6.5 years, Your Honor. This is a crime in violation of misconduct in office, MCL 750.505. Also 18 USC 241, 242 per the federal statute. Embler versus Patchman, the prosecutor does not have absolute immunity. Judge, and I exercise the common law. I demand that this case be heard under the common law, Judge. I've been home 6.5 years. No threat to anyone. I've been working. I have had 5 children since I've been home. I'm a grandfather. I have 2 grandchildren, 1 on the way. And I've been trying my best, and people have been calling, making false complaints on me, and it's well documented. I've tried to press charges, and the prosecutor won't do anything. This is selective prosecution, vindictive prosecution as well. It's all documented, sir. And I ask that this case, I would like again to challenge personal subject matter and territorial jurisdiction. Under MCL 767.24, the statute of limitations have told they have been notified of any pending warrants or anything else while I was incarcerated before I was released. I've been home 6.5 years, haven't been a threat to the community, haven't been a threat to anyone. People have made false complaints on me, and I filed police reports with the Department of Justice, the FBI, the state police, and DPD, the 10th precinct. And it's documented, and they don't want to let me press charges. This is selective prosecution, Judge. So
Thank
I
you,
ask
sir,
for dismissal.
All right, motion to dismiss is denied. I don't have the authority to dismiss the case. The issues you raised, sir, are more properly brought before the judge who's going to hear this case, which will be Judge Bryant, and you can raise those issues at your next hearing. What I will do at this time is set bond as follows. Counsel, what was your request?
People were requesting $1,000 cash as a result of the actions in this case.
Okay.
I object. He just said $1,000. He's being vindictive, Your Honor. I object.
Sir, do you have any financial means with which to post a bond of any type today?
I have $300 on one credit card, and I have $40 on another card, sir. And I'll be more than happy to give you whatever I have. I've been trying, Judge. I have tenants. I have my home. I have kids I need to get home. I haven't been a threat to the community. People have been lying on me, Judge. And it's well documented, man. And I told myself on personal report. And again, I object under UCC 1-308. I reserve my rights not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, and intentionally. Furthermore, I do not accept the liability of revealed contracts. Also, I would like to cite a case to the court, Foy versus City of Berea. 58 federal third.
Sir, I don't mean to cut you off, but I do not have the authority to dismiss as you requested. So it doesn't do you any good to give me all the citations. You can raise all of that with Judge Bryant on your next court date, okay? So court's going to set bond at $1,000, 10%. That'll be $100 to you, sir, which you've indicated is an affordable bond.
I got my card.
Yeah.
Yes, sir.
If for whatever reason you don't post, you'll have an affordable bond hearing tomorrow morning. But if you do post, you don't have to worry about tomorrow morning. Your next court date will be in front of Judge Bryant on June the 7th, here in 36th District Court for a pretrial, and I'm sure that she will entertain your motions at that time. Thank you, sir.
Can
You
I
can
ask you
step
a question?
aside. Sure.
Can I ask you a question?
Sure.
Can I ask you a question?
Go ahead.
Your Honor?
Yes, sir. Go right ahead.
I would like to state this, that the prosecutor is under oath under Article 6, Section 3. Right now, they're violating their oath. There is a case called U.S. versus Will. When they have jurisdiction to act and they don't act, and if they don't have jurisdiction to act, it's treason against the U.S. Constitution, sir, under the common law.
Okay.
I ask that you send this matter to the Michigan Attorney Grievance Commission judge because of misconduct on Kim Worthy and her subordinates.
Okay, sir. Again, that's something you can raise with Judge Bryant when you see her in June. Also, with regard to the bond redetermination date, that will be Wednesday, should you not post. If you post, you don't have to worry about it. If you don't post, that will be bond redetermination on Wednesday morning in front of Judge McConico here in 36th District Court. Thank you, sir. You can step aside.
Okay. You say what now? I can't post. Can I ask somebody to call somebody to post? Okay, yeah. Yeah, because I got them. Well, I understand. Your Honor, please. Thank you, Your Honor.
Without arguing with you.
No, ma'am. I'm very humble. I'm very humble. Well, I'm entitled to procedural and substantive due process. The statutes in which the state are charging me with are null and void in violation of the U.S. Constitution. The Shaney versus Winnebago Department of Social Service.
That's substantive. Stuff needs to be right.
Pardon?
That's the substantive.
Well, I've always learned as being a layman in the law, but I am.
You're not a layman in the law.
I'm a legal practitioner, not licensed under.
You're not a layman. You just don't have a P number or license.
Well, that's the corporate bar number, which is the corporate monopoly. They have tried to take over the legal system for their own benefit.
Well, that's an argument.
And once jurisdiction is challenged, it must be proven by the people exerting that.
But I can't address it until you put it in writing.
Okay.
That's what I'm telling you.
Yes, ma'am.
Okay.
Well, I just want to note for the record that I did challenge personal jurisdiction, which must be done on onset. There's a case from the Michigan Supreme Court.
It needs to be in writing.
Okay, can I
You're dumping all of this stuff.
Yeah, I'm just for preservation, because I've been wronged by Kim Worthy, DPD. They have committed crimes and there's evidence of this. Also, I'd like to change the venue from the prosecutor's office because of criminal misconduct is well documented. The gentleman on this case, who was my brother, he's speaking of, he's committed felonies.
I don't want to know about anything substantive on this case. I will move this to another court the moment you say something about allegations.
Okay.
Gladly.
All due respect, but I was just trying to.
I understand you have a lot to say.
Yes, ma'am.
You understand it needs to be a right?
Yes, ma'am.
Okay. Are you familiar with the courtroom?
Yes, ma'am.
Okay. So you submit it to the court and to the prosecutor, whether you think there's jurisdiction or not. You still have to submit it so that I can address it.
Yes, ma'am. I understand.
Okay. So are you familiar with this court's criminal procedure as far as why we are here today?
Yes.
It's called a probable cause conference.
Yes, ma'am.
Okay. So typically what happens next is we discuss discovery and the allegations that would be in writing, paper, police report, any video. You understand that?
Yes.
Okay. The prosecutor is obligated to provide that to you. So regardless if you think this case should be thrown out, the prosecutor still needs to do his duty to provide that to you. So I'm going to ask the prosecutor to provide that to you. What I want from you is your motion in writing to the court and to the prosecutor, so that I can make a decision. You understand?
Yes, ma'am.
You have a question?
Question. If I may just ask for additional discovery of in NCR 6.201, there's rules as well as Michigan Supreme Court People versus Stanaway, which deals with additional discovery.
Do you even have any discovery?
No, I didn't even know I had a court. They didn't
You
tell
don't
me
even know it would
anything.
be additional because you don't know what exists.
Well, what I'm saying is, so far as stuff that I would like to be brought forward concerning the prosecutor's office.
Absolutely. Let's get over what they have, and then you can make a discovery request.
Yes, ma'am.
But before that, you have to talk about venue because you're not even saying the right venue, jurisdiction, all the things. But the prosecutor is still going to provide you with discovery. So you need to look at that and see what it is that you have, and then you can request additional discovery, and then that you don't think that's sufficient.
Well, I mean, things outside, excuse me, pardon me, not things concerning this case, but I mean other things that has mattered concerning the alleged plaintiff, who also claims to be a sovereign citizen, my brother, and I need stuff from Judge Burton's courtroom.
Defendant, alleged defendant or plaintiff?
Well, I mean the alleged plaintiff. I'm sorry.
The complaining witness?
Yes.
Okay.
Yes.
Okay.
I mean,
so
I haven't
do you
saw
have an
my
email
brother.
address?
Yes, I do.
Okay, don't provide it on, we're on YouTube. Do not say it. I want the prosecutor to receive that from you so that he can see your discovery. First step.
Also, Mayor, I asked a question regarding what you said about YouTube.
Yes.
I know under the First Amendment, we have a right to record in public buildings, and also I would like to challenge.
Is it a right?
Yes, it's constitutional right under the First Amendment.
Okay, with no exceptions?
Enforced upon the state Bill 14.
Are you familiar with the exceptions?
Well, the federal law doesn't say it's an exception.
Does it? It doesn't say any exception.
No, it's a right, because you go to Macomb County, they have.
Just because Macomb County doesn't mean that there's no exception to the First Amendment.
Okay, I just wanted to address that.
Okay.
I don't mean to be rude.
I know you're being very respectful, but you have a lot to say. And I want you to put it all in writing.
Also,
I want you to provide your email address to the prosecutor.
Yes,
Do that first.
yes, ma'am. If I also may state that.
Let's do one thing at a
Okay,
time.
yes.
Your agenda is very long.
Yes.
Okay, so for the record, you have provided your email address to the prosecutor, right?
Yes.
Okay, so the next thing is, I want you to submit your motion in writing, okay?
That's now that you spoke about, being that representing myself appropriately signed up under.
My choice.
Yes, under Michigan Constitution of 1963, Article 113. When it concerns talent, I'm on home confinement. I need to go to the law library. I need to work to pay bills. I'm not a threat to society. I let officers in. The officers even stated that, what would I want to say? They even stated that, hey, you were very professional, et cetera, et cetera. Also at the other arraignment, the prosecutor spoke on my criminal record as a means of holding me in incarceration under People versus Allen. They cannot use your record against you unless you testify. And I have that citation from the Michigan Supreme Court. They have acted misconduct ab initio from the very beginning at this junction, this case at bar. I'm requesting that I'm not a runner. I don't have rap in my blood. I'm not a threat to the alleged plaintiff witness. He doesn't even live in the county. And the thing is, I also have another matter where the prosecutor's office came and arrested me for a 21-year-old warrant, and there's a statute of limitations for 6 years. Also, when I went to prison, there was 180 days. Now, the law says where the prosecution.
I know what the law says.
Please make this point, ma'am, under duress.
I need you, it's not duress.
Well, I'm getting,
You're not under
I'm here
duress
by
right now.
special appearance. I'm
I need
under
you to
duress.
step by step, just follow what I'm trying to help you do here. You need to educate me on certain things so that I can make a decision. Because some of this stuff, you're citing UCC, and I'm very familiar with UCC.
And
That's
the
where,
Boston
and
Supreme.
you cannot talk over me one at a time. I let you run off all your case law. UCC is for tangible, movable goods, not human beings. So, there you go. Write it, put it down in writing with all the things that you want to discuss. Because I can't stand here and listen to your oral argument. And
Oh, no,
you
it's not.
cite cases. We have 5, 6 other exams to hold. Okay,
Well,
I'm giving you.
I'm sorry, and I was just following the way that I was
We still
mandated by
talk.
court rules.
I'm just trying to preserve the record right now and inform you. So I asked for you to provide your email address. The next thing I want you to do is provide your motion to write.
Okay.
So I'm going to give you a date to come back. Okay, so you can make your argument.
Yes, ma'am.
The prosecutor will have the opportunity to respond. If they like, however they want to, or report to the court, as you say. So I will have you back here, today's the 5th. I want you back here on May 9th. Okay, that's the first thing. You will address bond. Okay.
Yes, ma'am.
So May 19th. In time. It's gonna take a minute. You come at 8:30?
Oh, yeah, I got up this morning, because I didn't even know I came down here just a goodwill, so I won't get caught up, with the cases. And that's what I was trying to address, if I'm
Yes.
allowed to go
You'll
work.
be here at 8:30.
Yes,
on
ma'am,
May
yes,
19th.
ma'am.
Okay.
And that's what I was saying, if I go to law library.
Okay,
so
let me, court date first, and fine. Mrs. Swan, you have anything?
Yeah,
Oh, we won't be here. We'll be in training. That's why there's nothing on the calendar. I want a day where it's let's do, May 22nd. That's not a good day. I won't be here. Can you do May 24th?
Oh, yeah, I'm on your, hear about the rest, man, force and coercion. So I have to comply with the court's order until we can litigate this.
What you want to comply with?
Oh, no, I have to do what the law tells me, because I'm under threat of force and coercion.
Hold on, don't start talking yet. Let me break it down. So May 24th at 8:30 is the date, okay?
is that PCC?
Motion here.
Motion here, okay, thank you.
And I'm going to provide you with the email address for you to send the motions to the prosecutor and to the court, okay? I have to send, please do not send anything in mail.
See, that's the thing, I was, need access to, like, let's say,
Okay.
go somewhere and type up
We'll get
stuff
that.
to be able
We'll
to
get to
learn
that.
how to scan.
Get to that.
Yes,
Okay. And we'll have the court email address and the prosecutor's email address on their report.
May I speak with the prosecutors, being that I'm co-counsel, I would like to speak with them maybe about a potential contractual offer agreement so where we can rectify. I'm counsel and he's the counsel. That's what I'm saying. I'm not considered a defendant to where if I was, being represented by.
You already wrong.
Yeah, I would be able to talk him or her or whomever's in charge. Yes, ma'am.
And just so you know, Attorney Washington is on standby.
Okay.
In the event that you ever request an attorney, he is well apprised and knows what's going on. That's what he's here.
Yes, ma'am.
This is a constitutional right, you have an attorney, you know. He's not gonna say anything unless unless you request that you need an attorney. Okay?
Oh, no, I'm fully versed in the law from A to Z, and I know the system's in and out.
That's
Yes, ma'am.
wonderful.
If I may address the fact of speaking with the prosecutor, because we save the state a lot of money. I don't have a problem with the state, but what my question is, to take me under Michigan rules of professional conduct.
Okay. All right, so now the bond, you are house arrest?
Yeah, I'm on tether. They say I can't.
Tether or house arrest?
House arrest.
I don't have your,
It was 10,000, 10%, with tether, no house. I can't leave the house. And, I'm trying to be able to move to go.
let me print it out and read, because I can't go. I can't listen to you. I have. Okay, thank you. Prosecutor and the court.
Oh.
Yeah, the court division. Thank you. All right. Right, you said 10,000, 10%. So you posted it and it says here, GPS tether requirement, house arrest allowed for travel, court, medical. Do you have a specific library that you go to?
I know it was one on Oakman, but I don't know. I haven't been there in years, like by Landwood and Oakman, because I stay over here on the next thing here at home. Yes, I could probably go to that one. That's the closest one. I don't know. Is it one down here, downtown, at the library? I can.
The main library.
Okay, I would, if it's okay for me to come down here, I could let my tether person know.
Well, I'm gonna let them know. That's what I want you to
Yes,
tell
ma'am. Yeah, the main library now.
Okay.
And,
I'll change your bond condition so you're allowed to go to the library.
and also, I'm a private contractor doing 1099 work. There's a Jerome Phillips Plumbing. I work with him from time to time. And then across the street from my house, there's a Robert Vane Diner. He posted my bond. He's a Russian immigrant. I work for him. He pays me. I pay taxes and bills. So it's 1099. I would like to see if I can work for you guys so I can pay my bond, tether, bill, my home, be able to go to the grocery market and get food, and I would comply with the court's order. I haven't been in trouble over 20 years, and these charges are ridiculous. And I asked the court humbly to allow this so that I may receive justice for federal constitutional kind of law.
Well, you have a responsibility. I you rented just to allow him to go to the library.
Yeah, yeah, Your Honor, we have a problem with that. I mean, these are multiple weapons charges, possession by a felon, assault, murder.
Objection, Your Honor.
It's
You
not
wouldn't let me speak about the facts of the case.
I can't hear his argument unless he's
Okay.
not interrupted. I'll let you respond.
We object.
I object too, because if you speak about stuff, I have a right, just being impartial on the Code of Judicial Conduct, County 1, that the judiciary is for the benefit of the litigants, not the judiciary. Code of Judicial County 2B, the court must adhere to Constitution and use equal protection and equal treatment in this matter. And again, since he's making an argument, I challenge personal jurisdiction, subject matter jurisdiction, territorial jurisdiction must be proven by the prosecutor. These allegations under Opera versus United States are hearsay. You must have cooperative evidence. At this moment, I would like to file a Michigan habeas corpus under MCL 3.303. And I
File that as well with the rest of your motion.
Pardon?
File that with the rest of your motion.
Okay, but my point is, if he's making an argument, I have the right under due process of the 14th Amendment procedural, the statute due process and the 14th Amendment to the same arguments and things of this nature. Under 3.8, this prosecutor was acting in misconduct.
3.8 what?
Pardon?
3.8 of what?
The Michigan Rules of Professional Conduct issued down by the Supreme Court of the State of Michigan. He has a duty to ensure that the defendant has a fair trial, that justice is based on evidence, not speculation or whatever else. And then he's remaining silent the whole time. There's a tacit agreement by him remaining silent. There he's equating everything that I'm saying is being true. He has to rebut that.
Okay, we're on the record of the people of the state of Michigan versus Cardell McCreary in all lowercase letters. 2305648. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to great bodily harm less than murder. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, and 9, weapons, felony firearm. Also count 10, weapons, felony firearm. Set for a motion here today. Appearances.
Edwin Sawaki, P5488, appearing on behalf of the people.
Mr. McCreary, say your name, please.
Carnell Michael McCreary, ill, all lowercase, acting appropriate persona under the Michigan Constitution of 1963, Article 1, Section 13.
Mr. McCreary.
Pardon?
Washington. Not here.
I don't need,
And I know that you say that you don't need them, but the laws that I have to follow state that this is why.
well, I object because
I understand you should object.
I made a motion because he does not represent me. He is not responsible for me. I made a quasi-contract, and it was served on the prosecution as well as this court. And the contract is clear and it must be enforced. Anything after this point, performance is accepted for the relief in the documents. There is not a corpus delicti. Where's the witness? Where's the victim? Where's the injured party?
You're getting into your motions.
Pardon? I mean, no, it's a quasi-contract which I sent to the courts, and it's clear. I mean, they have to either admit or deny the statement.
Okay, well, what does that have to do with Mr. Washington not being present?
Well, he's not my attorney. He's not responsible for me. I'm acting in appropriate persona, which the federal and state constitutions allow.
That does allow, but it also requires me to have an attorney present. That you request.
Well,
At any moment during your.
Again, I object. Jurisdiction is challenged, must be proven by the
Okay,
people on the
and you
onset of the
cannot
state.
get that until Mr. Washington is present, because for my job, I know you have a job, I have one too. For me to keep my job, I have to follow certain rules, which means that Attorney Washington needs to be present for me to hear these facts.
Well,
Regardless of what you say, if I don't do that, I am violating the law.
Well, I mean,
That I follow.
your performance is acceptance, Judge. You've seen the documents, you read the documents.
This is not a contract that I'm talking about.
Well, I'm saying, no, I made a presentment upon this court of people, a quasi-contract. Your
Yeah,
favorite
well,
kind of quasi-contract.
Yeah, and this is not civil law, so I'm not doing contract.
It's not civil law. We're dealing in the Admiralty Maritime Law Court.
You are.
No,
So,
this is the jurisdiction that this court is operating under.
I can't move forward. Did you email me all the report, all the
Yes,
documents?
and
Can you tell me
it
the email?
says clearly right here,
Can you let me finish my question? Which email did you send it to?
the one that your officer gave.
Was it the courtroom 438?
Yes,
Okay.
I made sure everything was delivered, it was served upon you as well as the people. And everything is being tacitly admitted to in this
I'm
document.
just trying to
by
proceed to make
everyone.
sure I have your motions, because I have.
Well, it's not a motion, it's a quasi-contract, which the Supreme Court of Michigan allows.
We can go back and forth. I'm not ever going to say that it's a quasi-contract. So you
I'll
can set that
just
down.
move for lien, Judge, against all parties, because everyone is in default, Your Honor. And the law is clear from the Michigan Supreme Court, which respondent superior applies to this court, that the decision stand. Stare decisis, Your Honor. This court is in default, as well as the people by their tacit agreement.
Okay, so.
I mean, the law is clear. He read the paperwork. He's a bar attorney. If he doesn't know the
Mr.
law,
Washington is not present. I have to adjourn this.
he's not representing me. That's why I
May 30th
in.
at 1:30. Can you make that day?
May 30th. Okay, I mean, I have a question, if I may.
If you answer mine, maybe.
May 30th, I have no choice. I'm here under direct threats and coercion by this court and corporate courts
Can
in
you
this
make
office.
it May 30th to 1:30?
I sure can.
Okay, so what's your question?
Well, my thing is, I mean, I didn't know that the judge could ignore the Constitution in which they were sworn to uphold the law of the common law court of the Supreme Court. All other courts are legislative created courts, which they make the courts, they make the law to enforce them. They're commercial statutes.
Question.
Pardon?
What's your question?
I mean, I'm just saying, I'm what my contract adhered to. The people who are remaining silent, they have agreed.
What's your question? You said you have a question.
I would like to know, can I go to the courts? As long as I'm going to court, I can leave home, because I would like to go to the federal court so that I may file a lien against the state of Michigan, the corporation, and the cities and county and state for crimes. You know, the prosecutor, Kim Worthy, has committed crimes against me. It's well documented. You're an officer of the court.
Is that what you filed with?
Yes.
Okay.
I mean, you are an officer of the court. You swore to uphold the law, and the people were acting criminal against me, and it's well documented. I have the alleged complaining witness on this case, Norman McCreary, has perjured himself.
Your brother?
Yes, I have documents here I'd like to admit to the court, so that I can impeach him. And like Kim Worthy has issued a list saying.
That would be something that happens.
Well, ma'am, what I'm just saying, jurisdictional challenge.
Once we get there.
No, what I'm saying is jurisdiction has been challenged. It must be proved from this point. Out of court statements are hearsay, man.
Oh, I'm very clear.
You see what I'm saying? So where's the corpus delicti? At this point, I moved to challenge jurisdiction again in the court. If not, I ask that the court strike this case from the docket for lack of jurisdiction, which the case law clearly states here.
Well, you know what? I would love to content,
Oh.
but I cannot.
Well, is it okay for the prosecutor's office to commit crimes in violation of MCL 750.505, Your Honor, 18?
It's okay, it's not okay for anyone.
Well, I mean, this is what's going on. I'm being deprived of my liberty as an American sovereign citizen, Your Honor. I'm being threatened under direct force, coercion, and direct force and coercion under Coins versus United States, 19 U.S. 264. They have incorporated the inhabitants. It started in Washington, D.C. and made us corporations today, and these are commercial courts. The Supreme Court has clearly stated everything and outlined everything, and it's in the law. I'm requesting that my contract be adhered to. The quasi-contract, which the Michigan Supreme Court and Caskett versus Magritta speaks of. I'm using the law of the land and of the state and the Constitution, and I'm being deprived of my liberty rights. So I'm asking that this court issue a writ of habeas corpus to have this case dismissed.
Against you?
Pardon? No, I'm saying against the state. You know, I'm here. They have to prove jurisdiction. They have to prove that I've committed a crime. Where's the corpus delicti, the body of the crime? I mean, everything is listed here, from the Michigan Supreme Court to the U.S. Supreme Court.
You know I would have to give testimony to know that.
Well, ma'am, once jurisdiction is challenged from this point, they have to present what they have. If they can't
make a
prove.
decision on something I haven't heard.
But did you read the document? I mean, like I stated on page 4, man, read something real quick.
No, because I have to wait for the actual hearing to hear both parties on the record. I'm not gonna respond to your
What party is
email.
missing?
I just told you.
Oh, the attorney doesn't represent me. This is what I'm saying.
And we all agree.
You know what I mean? So
We
I'm
all
just
agree
saying.
that you not represent.
Okay, well, I mean, your performance is accepted from all parties, so if you issue a lien to federal court against all parties.
Okay.
Because my rights are being violated.
I will allow you to go to federal court. Is that what you're asking?
I mean, well, I know in the order it says as long as I'm going to court. I mean, it doesn't really matter what court does it. I mean.
Well, you were asking if that was okay. I'm just letting you know. You're allowed to go to court. So May 30th at 1:30. Attorney Washington has confirmed that you were here to sit.
I've tried to call this man. He don't even answer his voicemails.
What are you calling him for if you don't need him?
No, but what I'm saying is I was just calling him to confirm with him, just asking a few questions.
Oh,
And he didn't even respond. I don't need an attorney, man.
Okay.
I am acting
That
appropriate for
confirms
something.
my reason why I'm here. Because time, if you have to ask him a question, he has to be.
Well, can I ask you, where is the victim here? Because crimes against the state are not permitted under Coins versus Virginia.
The complaining witness is not present because they did not
Okay.
change for exam to be present.
Well, once jurisdiction is challenged, it must be proven on the record, Your Honor. I mean, you're ignoring the constitutional mandates of the Supreme Court, which you are bound
Into
under.
all the law of the Jews. Okay, so May
You
30th.
told me to put it in writing, I did it, you guys.
I just want to confirm that you sent everything.
I did.
I don't want us to labor over any point on the 30th. I want to make this as.
Well, I mean, you guys are already in default, so I'll be enforcing the lien in the federal court, as well as seeking prosecution of this court as well as the state corporate office, because my rights are being
I understand
violated.
your route, which you're going, but I'm just telling you, I just want to make sure I have all your motions, okay? You sent them all.
No, it's a quasi-contract. If you look up
You
a
sent all of your
quasi-contract,
documents to the
Pardon?
court, you sent all of your
I
documents. that
sent
you wanted.
everything
Okay,
to the courts. I sent it to this gentleman here. He thinks it's funny. But see, what he doesn't know, his tacit,
it doesn't matter.
remaining
what he
silent,
thinks.
he agrees to everything
Mr.
that's
McCreary,
done.
I don't care what he thinks.
Yeah,
I don't.
statutes
I
are
don't-
commercial, Your Honor.
Okay.
And this is what the courts are enforcing, commercial
Therefore,
statutes against
we will
citizens.
see you on the 30th, 1:30, okay?
Right.
Anything from the people?
Your performance is accepted. I just want to state this on the record. Because right now he wants to speak, but before the hand, he doesn't want to admit or deny what's been presented.
He just said
His-
there's nothing to
his
say
sup-
for the record.
his
So he
sup-
does not want to speak.
Well, may I say this? His supervisor has committed felonies in this well documented. I did 15 years in
You
April.
should call the
Must-
police in.
I did. I contacted FBI, everybody. No one is doing that. I'm being denied as a sovereign citizen my rights.
That's an executive branch function.
Well, you say what now?
The judicial branch, we don't
Well,
court
but
crime.
what I'm saying is the court sua sponte, if the court feels that there's been a violation of the law, the court has the power to enforce the law. If you look at People versus, what was the case? People versus Hampton, where Judge Crockett at the time overruled the jury's decision, and the Michigan Supreme Court ruled that where a judge feels something is being violated
The
or.
jury's decision. We haven't
Well,
even
no, I'm
been
just
to
saying
an exam.
it shows you that you have the power
To
to
get to a
overrule.
jury, there has to be jurisdiction.
I'm challenging
there.
jurisdiction
I know.
now.
So we have
You're
to get there, Mr. McCreary.
You're a legal practitioner, you're licensed, an attorney, you're an elected, judge, you know the law. And the law is being violated, going back to Coins versus Virginia, they made us slaves and names in corporate, capital letters. 19 US 264 Coins versus Virginia. Everything that is being done is unconstitutional, it's criminal. I am an American citizen, not a corporate citizen, with all that. And this court is using commercial law. Even this flag that is being flown is a military court, Admiralty Maritime Court, and it's all Supreme Court. You can laugh all they want, but the Supreme Court saying this.
Nobody's laughing.
No, this man thinks stuff is funny, but I'm gonna have his job.
Nobody's
And
laughing.
his supervisor, Kim Worthy, is a criminal. And I mean, and I'm being respectful, excuse me, but I'm just saying I've been through too much. I lost my mother in prison. Now I got my own brother who is a known liar. He made court, affidavits to the court, what's his
I don't want
name?
to hear
Freddie
Mr.
G.
McCreary
Burton.
about your brother right now, okay? You have the opportunity to talk about all of that. I scheduled it at 1:30 this time. So we
Okay,
can have
so
a
we'll
full
have the
afternoon.
jurisdictional challenge on this day. I mean, he has to prove jurisdiction. That goes to the very authority of this court in the state law, federal and
Everything that you
constitutional.
want to talk about, you can talk about on the 30th,
All right.
okay?
I have, you give me something with his name so I can file an attorney grievance complaint. I have Kim Worthy's information in her file. But right now he's acting in behalf of her and I would like to file an attorney grievance complaint. So can you give me this gentleman's name and his P number so I may contact the attorney grievance board?
You put on the record, you can speak to him as counsel, you're representing yourself, you can talk to Mr.
Well,
Did he refuse to give you his name?
Pardon?
Did he refuse to give you his name? Okay, so we'll go off the record, May 30th at 1:30, and you can speak to the prosecutor as you represent yourself.
Cardell McCreary, ill or lowercase, natural person, not a person. If I may ask the court a question, address the court.
And good afternoon, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, as the standby attorney.
What's your question?
First, I would like to object, no disrespect to SY here, but he does not represent me.
I know that.
Okay. Yes, but the prosecution.
Your objection has been noted on the record.
And the
You have a
prosecution and them are.
You have a question?
Yes.
What's the question?
I didn't know that the court would allow the prosecution to commit felonies in violation of state and federal law.
That's not a question, that's a statement. Okay, so we have a.
Also, the question
You're
is.
not gonna talk with me then.
All right.
So we have Attorney Washington as standby counsel. He does not represent you, but in the event that you need help, he's there to help you. This is your request that we're on here today, so you can begin with your request to the court.
I don't, he's not representing me.
We've already established
Yes.
that. So you can begin.
Yes.
I have your documentation here, so you can start.
I haven't had anything from the prosecutor's office. You gave the prosecution 2 orders to give me discovery under People versus Davey. The 225 Michigan Appeals 592 violation of a discovery order is grounds for dismissal. Also, I would like that the court, as well as the people, provide their bond numbers, their licenses to practice law. Yes, and their oath of office. Because right now at this point, I'm being violated. I would like to also have Kim Worthy here, the chief prosecutor, because she has committed crimes past and present. I would like a change of venue because DPD has been continuously retaliating over years. It's well documented. People have been lying, making false complaints. They're using known perjurers. I've made reports with Detroit police, and I'm not being given the same rights as any other citizen. If a person is being called in and they're saying, well, hey, Mr. McCreary did this and did that. They come to my house. They bang on my door. They're impeding upon my freedoms, my sovereignty. They're a corporation. Corporations cannot act upon natural persons. Now, the case of Coins versus Virginia, 19 U.S. page 264, says that it started in D.C. They incorporated inhabitants of D.C. and the states, other states. I am not a corporation. As I stated numerously in the beginning of this case, ab initio, I reserve my rights not to be compelled to perform under any contract or commercial agreement. I am a Moorish national sovereign. This court, as well as the people, have violated the Moroccan-American Treaty of Peace and Friendship of 28 June of 1786. Now, this quasi-contract that I presented to the courts, per the Michigan Supreme Court, the U.S. Supreme Court, this matter has already been litigated. And this court, as well as the people, are in default. And again, they refuse to give me their bond numbers, their names, and things of that nature so that I may properly file a lien in the federal court, as well as I'm preparing a 42 USC 1983 case. Again, the state has no duty to protect private citizens from private citizens under the Cheney versus Winnebago Department of Social Services 489 US 189 1989. If you go all the way back to the civil rights cases, the 13th and the 14th Amendments were created to protect African Americans from discrimination by city, county, and state and federal governments. And it also says in this case as well that they have no duty to protect private citizens from private citizens. So to compel performance of these corporate statutes, which it speaks about in Coins versus Virginia, again, 19 U.S. page 264, they created statutes to corporately punish the inhabitants of the city of Washington and the District of Columbia, and it went down into the other federal territories as well as the cities, counties, and the state governments. And they're committing fraud against the people. These these statutes that they have me charged with are unconstitutional. And I ask even though you're in default, I'm giving the state another chance, but this right here is already locked in. They're in default because the law says where they have a legal or moral duty to respond. Their silence is their acquiescence, their tacit agreement. So they're in default, Your Honor. And I would ask that the court subpoena Kim Worthy here so that we may put her on the stand to answer for her subordinates' criminal behavior as well as her criminal behavior. Have documents here where it's clear that they, can I sit down for a minute? My back is kind of bothering me. That's what my legs are shaking. But I would like Kim Worthy to be brought in so that she can be questioned about the change of venue, the allegations, which are factual. But they sent me to prison for 15 years and 8 months for no crime at all. Judge Kirsten Frank Kelly was in Wayne County. She issued an order against me that was null and void. I was railroaded, sent to prison, did 15 years and 8 months where I lost my mother, family time away from my daughter who's now 24 years old. She's a mother. I'm a grandfather. I've been productive in the community since I've been home. They're trying to make me look like I'm a demon. But the paperwork shows the opposite. And I would like all of these things. I would like an evidentiary hearing so that we may put these documents into evidence and that this case can be properly litigated because the prosecution is committing crime. So I ask that this court use this subpoena power and adhere to their oath of Article 6, Section 2 of the U.S. Constitution, as well as Michigan Code of Judicial Conduct, Canon 2B. And the paperwork is clear. They refuse to respond. Everything that is happening now is criminal. In violation is conspiracy, 18 U.S.C. 241, and in violation is Michigan misconduct in office, MCL 750.505. I have been humble with this court. I haven't been here just trying not to disrupt the court. I'm under threat, duress, and coercion. You know what I'm saying? They have constantly been retaliated against the Detroit police as the sheriffs, as well as Kim Worthy's office. And it's well documented. They sent me to prison off the testimony of a perjured witness. And I would like all these things to be adjudicated properly in this matter. And jurisdiction has been challenged per federal and state case law. The people have to prove jurisdiction. They have statements. The corpus delicti rule bars statements as hearsay out of court. And this is what they want is they cannot make an affidavit for anyone. You see what I'm saying? My brother, as they claim, made these statements. I still haven't been given any discovery or anything. And they're in violation of the Michigan Court case law, Court of Appeals case law, and People versus Davey. This court clearly twice told me to give them discovery, 225 Michigan Appeal 502. And they're still violating the court's orders. And this court, honorable court, should exercise the contempt powers and have these officers supposedly acting for the court, which are being criminal, to be put in jail until they comply and or fined. Detroit police has a history. They were prosecuted by the Department of Justice in 2001. Then they were under the consent decree into 2013. And they're still committing atrocious criminal behavior and acts against natural persons, natural citizens. You know, Judge, you're familiar with this case law. You're a licensed attorney and an elected or appointed judge. I don't know. But the Supreme Court under Marbury versus Madison rulings, they're decisive, let the decision stand. This court is bound to adhere to Supreme Court rulings. These statutes in which they're charging me with are unconstitutional in violation of the civil rights cases, as well as Cohen's versus Virginia, the Supreme Court. And today, again, I respectfully compel this court to adhere to these things. And the Supreme Court says where a court does not have jurisdiction to act, or where they don't have jurisdiction to refuse to act, it's considered treason against the U.S. Constitution, right? And the paperwork is clear. All parties that I've served these papers on are in default, Your Honor. And I ask that this court, like on page 13 and 14, I clearly stated in the offer, I'm the offerer, they're the offerees. And this process is approved by the Michigan Court of Appeals, Michigan Supreme Court, in which they cite federal court cases on the federal court cases, cite these cases as well. Give me a second, please. On page 13, it says, offerees 1 and 2 agree that all above and below statements are true, and they have until May 24, 2023 to admit or deny the above, and agree that terms, A, failure to hold state laws unconstitutional, and void ab initio, agree to give me in the sum of $5,000 in gold and silver coins and or Federal Reserve notes and assets in their personal and official capacity. B, failure to dismiss charges with prejudice and grant all of the above, all of the supra and infra, agree to give me $500,000 and agree to be charged via MCL 750, 505, 18 USC 241, 18 USC 242 by the U.S. Attorney and the state's attorney for their crimes via Turner Associates Inc. versus Small Parks Inc. 59 Federal subsection 674 at page 680 through 82. Eastern District of Michigan, 1999, where they have a legal and moral duty to speak and agree that if they, offerees 1 and 2, try to impair this quasi-contract, argue or try to litigate this case further, instead of dismissal with prejudice, agree to give me $1 million in their individual capacity via Holland versus Earl Graves, Publishing Code 46, Federal subsection 681 at 685 through 687, Eastern District of Michigan. Then there's affidavit of truth. I, Cardell McCreary, says that the above is true and correct, and email these pleadings to offerees 1 and 2, which is Kim Worthy, as well as this court on May 10th of 2023, and I signed it. The law is clear, Judge, and this court must enforce the law as written by the higher courts. This court is an administrative district court acting on a corporate level, and they cannot conflict, basically issue their rulings in conflict with federal Supreme Court ruling, which they have taken an oath to do so. If this honorable court refused to do so, it would be treason against the U.S. Constitution. And I ask that this case be dismissed at this juncture because statements, I have not been given anything by the prosecution and the people. And I would also ask that this court exercises subpoena power and have Kim Worthy come here. She's not God. She's not a queen. She's not an empress or anything. She's an elected official. And her history precedes herself as committing crimes against citizens like Devontae Sanford, Daryl Siggers, all these people that they're saying that they're trying to help get out of prison under the wrongful convictions unit. Valerie R. Newman was my former attorney, and that also makes it a conflict of interest because Judge Kirsten Kelly heard her on appeal. She let the judge do it, and I had to do almost 16 years in prison for a crime where there was no legal jurisdiction at all. And there's documented evidence, paperwork, court seal, signature, and I'm being criminally retaliated against by the people. There's no way they can wiggle their way out of this, and I would like these things to be adjudicated and evidence. I would like an evidentiary hearing so we can admit evidence and or suppress evidence. I haven't been given discovery. I didn't even know I had court the first time I came. I had to go online and look it up. These are the games that they're playing. And I would like their oaths of office, their bonds, as well as other things. Because they're committing felonies, Your Honor. All due respect, and I like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child and the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robinson. when he was in office many years ago, he did the right thing. They tried to get him to send these young juveniles to prison. He said, no, these young men can be rehabilitated. And he sent them to juvenile prison. At this time, the prosecutor then went and attacked this judge. You see what I'm saying? You have a right and a duty to fulfill your constitutional oath, Your Honor, regardless of what they think about you or whatever else.
Good morning.
Good morning, Your Honor. Yeah.
Good morning, everyone.
Good morning.
Are you ready on the motion for Michael McCreary?
Yep.
All right, the clerk can call the case.
2356485, the people of the state of Michigan versus Cardell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, 9, and 10, weapons, felony firearm. With the habitual offender fourth defense notice set for a preliminary examination today. Before the exam, there was a motion that was filed by Mr. McCreary to disqualify me from this case, and that is why Chief Judge Carnell is on Zoom to address that motion.
Okay, appearances.
Edwin Sawaki, P54A2A, appearing on behalf of the people.
Carnell Michael McCreary, natural person, not a corporation, natural flesh and blood.
Okay, thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Aliyah Sabree pursuant to MCR 2.003. The court, having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabree, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabree is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case. So the motion is denied. Thank you very much.
And Attorney Washington, I know you want to put your appearance.
Oh, yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak, Judge?
That matter.
Now that matter is resolved now. The court is turned over back to, excuse me, sir. The motion was denied. And now the court is being turned back over to Judge Sabree to handle the preliminary examination. Thank you very much.
Well, can I at least place my objections on the record?
It's been noted.
I mean, I'm just saying
Mr.
because
McCreary,
I thought you were the chief.
Mr. McCreary, your objection has been noted.
May I address the court?
Not on that matter. I can't hear a motion to disqualify. According to Michigan Court Rule 2.003, the chief judge has to address it in a multiple judge court. This is a multiple judge court. Chief Judge McConaughey just addressed it. You received your motion in writing and he responded on the record and he denied it. There could be no more discussion for me about the disqualification motion, Mr. McCreary. It's been denied.
But can I just address something? I mean,
it's already been addressed in your pleadings, and I cannot respond. I don't know if you understand. I can't respond regarding the disqualification.
I'm not trying to do that. What I was saying per the rule, due process.
You're still talking about something that has nothing to do with.
Well, I object, and it's on the record.
Yes, and I've noted that. So as far as the exam, the time is now 10:17. Are you ready to move forward with your preliminary examination?
I came here today with intent, like.
Yes or no?
No, I'm not prepared because of this. I mean, you won't let me speak, Judge. Like,
I
you give
let
him a
you
fair
speak
chance
in regards to what
to
I'm asking.
respond, but you won't give me a fair chance to say or speak.
Mr. McCreary, I let you stand here for 45 minutes last time we were here talking to you, didn't have anything else to say. So today I'm asking you, are you ready to move forward with your exam?
No, I'm not. I would like to call
Based-
witnesses. and
Based on
subpoena.
what?
Pardon?
Based on what?
Because my intent as today, this motion was filed, the court was supposed to deny it because I thought you were a chief judge pro tem. And per the motion, it says that if you were the chief judge pro tem, it's supposed to go to the state court administrator. This gentleman here, I'm not familiar. Like first, the
You're still addressing the motion to
my
disqualify.
due process is being
And
violated, Judge.
it's not.
I mean,
Because if
you won't
can
let me
read,
tell you
it seems
why.
as if you can read it right. The court rules are very clear about motion to disqualify. There's no black, it's black and white.
But
So, Mr. McCreary has been denied.
okay, we
And
understand
if you
that.
knew that, it also says that the timing in which the court can address that can be any time. So you knew you need to move forward with your exam today.
Well, what I'm saying is
So-
I have a right under 6.110
So-
to call witnesses,
Yes, you
things of that
do.
nature.
And why aren't you prepared today?
Because you won't let me speak.
I
Your
didn't,
Honor.
no, I said, why aren't
I'm
you
trying
prepared
to,
today?
I'm trying to tell you.
Today's your exam date.
Can I respond? You keep cutting me off, Judge.
You're not answering my question.
I'm not prepared because when I filed this court was supposed to make a ruling. Then if you denied it, it was supposed to go to the chief judge.
No,
That is
I
the
can
process.
tell you no. It's not.
That's why I'm not
I can't deny a motion to disqualify in a multiple judge court.
Can I pull up the
Read the
rule?
court rules,
Can I-
2.003.
I'm familiar with it very well.
We're not that
In
familiar.
Crampton versus Michigan Department of
I mean,
State,
you
said
can
even if
say
you
any
can't
case
show
law you
bias.
want in a multiple judge court. I cannot handle your motion that you filed. It goes to the chief judge. Chief judge, I am chief judge pro tem, two different things. I cannot handle my own motion to disqualify. That would be bias, Mr. McCreary. So do you have witnesses subpoenaed?
You won't let me respond.
Yes or
Judge.
no?
No, I don't.
Okay.
Because my intentions, as I stated, under
It's
this
just a
rule,
yes or no. I just
No,
want to know.
I mean-
So you can finish looking under court rule 2.0.
why am I not being allowed to address the court and give it a fair exchange like the
I'm asking you
prosecutor's office?
questions. This is not your courtroom. I'm
I'm
asking
not
you.
trying to
I
disrespect
have
this court.
given you
Judge.
all the leeway up until this point.
I mean, the law
Today's
gives
the
me
exam
rights.
date. Go ahead and check your court rules. Get back to me. Are the people ready to proceed?
People are ready to proceed, Your Honor.
And I object, I'm not ready. Because, I mean, I would like to address the record for preservation rights. So far as I have to go to the
Do you
higher
want to
court.
research 2.003 first? Because that seems to be what you were stuck on. Maybe, I want you to go ahead and
I
find
mean,
that
there's
first.
Michigan case laws, but Judge.
Court rule 2.003. Go ahead and find it. Tell me where it says that I'm supposed to address it.
Okay, section B, who may raise, the party may raise the issue of a judge's disqualification by motion, or the judge may raise, excuse me. Disqualification of judges warranted for reasons that include but are not limited to the following. The judge is biased or prejudiced for or against a party or an attorney. B, the judge based on an objective and
Those are the
reasonable.
grounds. You gotta get to procedure.
All right.
Section B.
Oh, my goodness.
Three. A. Start there. I can read it for you. 2.003 D3 under ruling.
I mean, I was getting down
One,
here.
in
You
a
say
court having
B3?
2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge who shall decide the motion to no. That's what happened. There's a written order that will be provided to you stating the time. So, Mr. McCreary, I am ready to move forward with the people's witnesses.
Well, I have evidence, I mean, since you're forcing compelling, which violates my rights under UCC 1-3. Also, I'd like to make a non-pro time. Again, motion to challenge the jurisdiction of the court. After this, the hearing we had last, I believe it was the 30th, I believe it was. The prosecutor gave me 15 pages. He had tested on the record, 15 pages on the hat. There's no warning. There's no signature signing off for the prosecutor to initiate charges, whatever else. I mean, this whole case, I object to this case being moved forward under Brady violation, Fourth Amendment violation. I mean, they're committing crimes here in this courtroom, and this judge, you're allowing this.
Nothing has been presented to me.
I mean, I'm just saying.
I'm talking. Stop talking over me. You've been doing this since you've been in this courtroom. Every time you talk, I let you finish, whether it means it's meritless or not. I haven't heard anything of any substance or any value worth me addressing when it comes to Brady violations. So I'm ready to move forward. And if you want to call witnesses, if we have to hold in part because you didn't subpoena them today, we'll address that when it comes time after the people rest. So, Attorney Washington, is there anything you'd like to put on the record before we begin?
No, Your Honor.
Okay. Any preliminary matters from either side regarding the exam?
Preliminary matters, yes.
People have to address the court first.
Yes, Your Honor. People have exhibit 1, which I will show to the defendant and his Mr. Washington here. It is a register of action certified, case number 98007-861-01-FH. It indicates that defendant, Mr. McCreary, pled no contendere, assault with intent to maim, would like this as people with exhibit 1.
Oh, you say, I was found guilty. Assault with intent to maim. Hold on, he said I was convicted of that?
Under what court, under what statute?
Oh, I'm sorry, Your Honor.
I object, I wasn't convicted.
MCL 766 11B 1B.
I object to that, Judge. I was not convicted of that. Matter of fact, Judge Dalton Robeson was a visiting court. And again, this gentleman is lying to the court. He just lied to the court. That's perfect.
And you had the opportunity to review the document?
Well, he said that I was convicted of assault with intent to maim. Can I ask that what you said?
I said, you pled no.
No. I wasn't found.
Mr. McCreary, you review the document first?
Yeah. Okay, well, what does this got to do with the case? Robbery not armed, assault with intent to maim. I have the transcripts at home. And the court order from Judge, he was a visiting Judge Dalton Robeson. Matter of fact, in that case, Your Honor, the prosecutor, what was this, Thomas Beadle, I believe his name was, he said that the officer in this case lost his entire file.
Can I see the?
And I have this transcript at home. How you gonna speak on someone you lost a file? This case was the felonies was it was a misdemeanor, aggravated assault. And that's the case that, because in the transcript that I have at home, I would like to make that in evidence after this is concluded or whenever I can. Because he's just lied to this court, Your Honor. That's perjury committed in court, Your Honor.
Okay, I have a seal here from the register of action sealed from the Wayne County Clerk's office stating that you pled no contest to
That's inaccurate.
assault with intent to maim.
That's inaccurate, Your Honor. I had a transcript at home.
Can you let me finish what I have to say, please? The jury trial was held in front of Judge Roberson. You were sentenced and committed to Wayne County Jail. Your sentencing on September 8, 2000. That's it. So for exam purposes, under MCL 766.11B1B, exam purposes only. This satisfies with you can place your objection on the record.
Well, I would like to say, because in this case, I have the transcripts at home. And I object because this man just lied to the court, because in this case, that Thomas Beadle was supposed to be the special prosecutor. They held me there for 2 years. And he stated on the record, there's no support for this case. The officer in charge lost the entire file. So how are you going to present a register of actions? That's not evidence, Your Honor. I have the evidence at home. And I would like to object to this, and I would ask that you hold him in contempt of court for committing perjury.
I'm going to hold you in contempt of court in a minute if you keep talking over me. So I'm going to admit as Exhibit 1 over the objection of defense as a certified copy from the clerk's office for exam purposes only, showing that Mr. McCreary was convicted of felon intent to maim in 2000. Anything else for preliminary matters?
Not from the people, Your Honor.
Okay.
Also, Judge, I would like to make a motion to sequester because my intention is to call the chief detective on the stand because.
Okay. You don't have to tell me a theory. I will do it.
Okay.
So let me do that first. So if there's a potential witnesses on this case, now's your time to log off. As far as in the courtroom, if there's anyone present who may testify on this case, maybe a witness, now's your time to exit the courtroom. What's next?
Per the court rule, I'm allowed to admit evidence for evidentiary purposes of impeachment on people versus Stanaway. I also would like to address to the court Kim Worthy meetings last year for the witness list out for officers who have previously testified falsely in court proceedings that they couldn't testify in future proceedings. My brother, Norman McCreary, has committed perjury in front of Chief Judge, Wayne County Chief Judge Freddie G. Burton. He committed forgery as well as identity theft. Also, I have affidavits from my other brothers where they've been trying to press charges. I tried to press charges. And the prosecutor ended up not doing anything. Also,
can I address that first?
Yeah.
So, Mr. McCreary, if your brother testifies, you can definitely cross-examine him, impeach him, and bring all of that out. And if the prosecutor objects, we'll address it then. Well, but you can do that on purpose.
I need to get y'all copies.
No, I don't receive copies until you introduce it and it's provided to the court. I don't do any preliminary impeachment. So once you cross him, if it comes out that he was convicted of a certain crime under the court rules or under evidence that allows you to discuss it, then that's your right to do so. Next.
I would just like, he was not convicted, but he was in the courtroom that was established by the Chief Judge Freddie G. Burton. And my other brothers were kept in the line all these years and they're trying to come forward. And I have an affidavit on my phone from my brother that's notarized. He's in the state of Florida. And
the brother that's testifying today?
No, my brother Charles, I have 5 of them.
So you have to address your brother today when you cross-examine, okay?
Also, again, I would like to renew my motion to have the prosecutor's office withdrawn because of criminal misconduct, conflict of interest. My former attorney works for Kim Worthy as the director of the wrongful convictions unit, Valerie Newman, and it is quite well documented that Kim Worthy, as well as my former attorney, committed felonies. And it's all a matter of public record. And, you know, for this gentleman here to come here and try to mislead the court, I believe it's under 3.3 of the Michigan Rules of Professional Conduct. It states once an attorney knows, I believe it is, that they have told the court something, they must correct it. And this prosecutor is committing misconduct because I have from a stenographer transcript at home, in which I would like to.
You know the avenue to do that. If you want to report misconduct, you already know that. So let's get started with the exam. I've heard all of your motions and you place it on the record, and you will of course order the transcript to be able to move forward to the next steps which you want to do. So any other preliminary matters to address regarding the exam today?
Well, how about, I'm just saying this, the proper recusal aspect.
I'm going to deny that.
Well, can I place my objection?
Absolutely. I hear your objection. Everyone else does. Ready to call your first witness?
Yes, I am, Your Honor.
Mr. McCreary, do you want to sit at the table up here?
I would ask that the police officer be called first because we have to establish how he investigated and other things that nature.
Now that would be you working for the prosecutor's office. You don't get to tell them how to try their case.
No, I'm not saying that. What I'm saying is I want to question that investigation.
Okay.
Judge.
I'm denying that request. I know you like to object. Please object so we can move on.
Judge, I mean, okay. Now, like I already placed my objection, I'm being denied my rights to a fair trial. Okay.
It's not a trial. That's
not my trial. Well, this is a hearing. What I feel entitled to my rights in a
hearing. It's not guaranteed by the Constitution. It's a statutory right.
Well, if there's a federal right, we have 2 different things. All respect to the court.
And I'm sure mine is right when it comes to whether or not you have a constitutional right to an exam or whether it's statutory.
Okay. All right, I'm ready with my question. Okay, so are you familiar with the law in Michigan so far as state statutes, state laws, and things of that nature? Do you have some form of, did you receive some form of legal training when it concerns your job? You went to the academy back in the day.
Yes.
Okay. Did you know under MCL 750.505 misconduct offense that is a 5-year felony that you have committed against me, sir, based on lack of evidence and no warrant, sir?
I'm gonna object.
Well, the objection is not founded, prosecutor.
Let us know what is, I don't know what's objection.
Relevancy, defendant's testifying, he's accusing of crimes,
Argumentative.
argumentative.
I
So the question just doesn't make sense.
Can I respond, please? Sure. I mean, he goes for purposes of impeachment, Judge. And then, like I was stating, Kwame Kilpatrick was sent to prison for the same thing that he's doing. And I mean, he was the mayor.
You're not about to convince me anything, mentioning Kwame Kilpatrick's conviction, so.
All right, well, I mean, can he answer my question? I mean, if he's a law enforcement officer, he should have no problem answering questions.
Well, it's not relevant.
Well, it's relevant because he's committed a felony, Judge.
That's an accusation. It
It's
has not been presented to the court in any matter other than you telling him that he committed.
Well, can I, again, ask this court on the MCR 6.201 Brady versus Maryland, request his background history for purposes of impeachment and People versus Stanaway, which allows.
More discovery?
Yes, I would like to have more discovery so far as impeaching his witness because.
So, Mr. McCreary, if this is found over, I will sign discovery order.
Well, I'm just saying is I need it for purposes of the exam under MCR 6.110 to properly cross
Discovery
examine.
is ongoing, it's ongoing.
Well,
So today, the exam, we're in the middle of it. We have plenty of time to prepare for this day. If it gets found over, I will sign discovery order and you can request.
well,
Okay.
yes, ma'am. Under People versus State, again, I say that citation I will have today here in court where Judge Robeson dismissed a case against the prosecutor as a sanction for withholding evidence. He knew that his witnesses would be here. Then he didn't.
That's an argument that you can discuss during the argument once you're ready.
So he's not allowed to answer the question that I asked him so far. So.
No, I'm just saying.
Okay. Are you familiar with Mr. McCreary or your department, the 10th precinct at all? Have you ever had any knowledge of him coming to your department or complaining about your department or anything to that nature?
For this case, I never had any contact with him.
Okay. Are you familiar with the Sergeant Ball that worked at your organization?
Yes.
Okay.
Wait 1 second, sir. Is it the one that's retired or the sergeant?
He's retired.
Okay, because there's two balls there. The sergeant at some point. I just want to make sure I have the right one.
Yes.
Okay.
Okay. So when you did your investigation, how did you come about knowledge of Mr. McCreary beside with his brother? How did you know how Mr. McCreary looked? What information did you find out where he lived? Did you do a lien check? Did you check the system for pictures or addresses? Did you do any of that, sir?
So typically when I get a case, it pops up. We call it our hopper. It's where it lists all of our cases we got for the day. I make my initial calls, try to make contact with victims, and get them in for another written statement because sometimes we get a release from people's minds are elsewhere, or they don't ask the right questions. I might need more for my investigation. I might get them to come in, either me or someone else who might be you. Get a written statement from them so I get more of the story. That way, once I do send something like this over, whatever I get, I can put on paper and I send it over to the prosecutor. If they think there's probable cause to go forward, and then a magistrate thinks that, then it gets signed. If they don't, then I can only present what facts I have.
Okay. At your precinct, you guys have a warrant prosecutor?
A warrant prosecutor?
Yes. Typically, I remember from back in the day, even now, like they have assistant prosecutors available so that they can sign off and stuff like that. And that's relevant. He's part of the
And also, I'm gonna check from the OCS.
Other than you establishing in your argument that there was no warrant signed, what is your purpose?
I'm trying to show how his investigation came forward. I know I've read things concerning the Fourth Amendment. Fruits gathered after and illegal search and seizure are inadmissible in court. And I'm trying to establish that. I remember from back in the day that they had prosecutors readily available that could sign off on stuff like this. The prosecutor didn't even sign off on it. And I'm just trying to.
I'm sustaining the objection. It's not relevant right now. You can put that in a motion if it gets filed over.
Are you aware that Mr. McCreary, past and present, has come into your precinct and made complaints against your officer there?
Your brother, Norman?
No, me, Carnell Michael McCreary. Ill.
I'm gonna object.
Oh, not relevant.
It's for purposes of impeachment, Judge. That's how it's
Everything you
relevant.
keep saying is for impeachment.
People versus Stanaway.
Yeah,
Stanaway allows.
it does not say you can impeach on anything. I know that case law does not say that. You can say anything and it's impeachment. That's not how impeachment works.
Well, I'm trying to show and establish retaliation by DP.
Okay.
Because of numerous complaints against them, because of recording them, putting them on YouTube, when they told an officer to break in the house.
On the stand, doesn't know your brother apparently until this case is filed, and doesn't know you. So can we move on to something else about what happened on the date and time of the investigation regarding you and your brother's complaint?
I mean, yeah, I objected again to this court's handling of this case. I had something in mind, but you put me off. This gentleman here. Okay. Did you ever look at Mr. McCreary's picture? It was stated in here that you showed, or one of your officers showed Mr. McCreary, my brother Norman McCreary, picture. Is that correct?
Correct.
Do you know what picture it is? Do you have a copy of that picture here today in court? Because that wasn't in the discovery.
It's included in my packet. It's an over the APA's office. It's the Michigan SOS picture provided to me by the law enforcement information that we call link.
And what came up in the links? My driver's license, or what came up?
The Michigan SOS picture, yes.
Okay. All right. Your Honor, can I have the court officer show the prosecution's witness something?
Your Honor, it's your witness.
No, I have.
What is it? I don't even know what you're trying to do.
I'm laying the foundation. He's keep trying to shoot
What are
me
you
down.
trying to do?
I mean, I'm trying to figure out how he came in contact with me, how he came about. He just stated in here, so I'm going to show my driver's license. Okay. Did you ever look at Mr. McCreary? And I object, Your Honor, to the denial of that. Did you ever look at Mr. McCreary's driver's license?
His actual license? No.
Which Mr. McCreary?
Me. I'm talking about me when I addressed me. Well, Carnell McCreary. Did you ever look at Cardell McCreary's driver's license when you did the investigation?
Physical license, the one that's in your wallet? No.
Okay, but what I'm saying is in the system.
It wouldn't be your license, it would be the picture provided by Lean.
The picture by Lane. Oh, okay. Lane system. I didn't. Okay, so I believe on the paperwork it says a CTN. What is that? A CTN, sir?
CTN?
A CTN, like on judgments, warrants, things of that nature. It says CTN, then it has ORI.
You asking me what a CTN is?
Yes.
So that's going to be generated by the system.
No, I'm saying you give me a breakdown and define what CTN.
It's not something I deal with on my end.
Okay, may the people, attorney, since he always wants to object, can you tell me what a CTN means, sir? And help you with it?
I'm not testifying.
Okay, so you don't know what a CTN. Did you know that a CTN is?
I don't have objective, bro.
I haven't finished.
I don't see the relevancy of the CTN.
I'm just saying is I haven't finished my line of questioning.
Well, I can't imagine what a CTN has to do.
Well, it's a cargo tracking note.
I'm sorry, what?
It's a cargo tracking note.
Okay, and that's not relevant today. So next question, I know you objected to that as well. We'll place on the record,
So-
Mr. objection to my piece of saying that objection. Go ahead.
So you stated that you looked at my ID and whatever else in the link said.
Right.
Okay. Did you know that me, Colonel Michael McCreary, reserved his rights not to be governed or controlled by city, county, state, federal officials? Well, I mean, it's relevant. I tried to establish
It's
relevancy.
relevant to you, Mr. McCreary, but it's not relevant to the case here.
Well, it's relevant because I'm not the straw man judge. I'm not
Okay.
doing business with the corporation. This is what I've been trying to
And you
establish, but
have-
you're limiting my
I am.
defense. My
I am.
defense, Judge.
I am.
What about the motion so far as additional discovery to impeach him for?
What did I say?
I'm not gonna help you.
What did I say?
And I have those
What
rights.
did I say?
You said after the fact, it was filed over, you will sign a discovery order, but I'm entitled to that to do a proper defense.
That's what I said. That's not gonna change.
Well, under federal law, I have a right to present a defense, and this court is denying it. So
No, I did not deny you at all. We've been here for over an hour. And you've been presenting things to us.
Okay, I can't question this guy because, this officer, because the prosecutor keeps objecting, I'm being denied the right.
Well, maybe because you're not that great at
I'm very well, I have a right
You're not
to.
that well versed with the court rules or evidence.
Well, I fight with constitutional law, which you have ignored, which you have.
You definitely fight with it.
Well, I'm just saying, under the
But-
Constitution, this court is bound by that.
I know what I'm about by. Do you have any other questions?
I'm being denied, so I would just object, and then I would, if it's bound over, I would do a motion for a remand back to this court in front of the circuit court with paperwork. And, like I said, I'm in the process, I should be taking that down in this coming week to the federal court. And I would like also to have this case removed to the federal court.
Do you have any more questions of the witness?
I can't question
Yes
them.
or no?
No, I can't because I'm
Okay.
being denied.
Okay, any cross?
No, Your Honor.
Okay.
Thank you, Your Honor.
Any other witnesses or defense?
Yes, I would like to call the other witnesses listed on the paperwork.
And what did I say about that?
And you deny it.
I said you did not subpoena them or ask the prosecutor to make them available for you to interview them for the exam today. So they're not here, so you're not prepared to call them.
Well, I just want to say this for the record, so just in case the higher court looks down the line at this.
Sure.
And like I tried to explain to the court, it was my intention based on the reading of the rule in the case law. It says even where you cannot show actual bias in the Supreme Court, that you would be removed and then I would have time to prepare these motions and documents. And I'm being railroaded by this court as well as the people who just admitted they have no warrants, they had no evidence.
The higher court, that's why I'm at the district court level, so that's what higher courts are for, so they can address.
What is?
I'm not threatening you. Say one more word and that's 30 days. 30 days.